and I would like to thank the organizers for giving me this opportunity to speak in front of this audience of architects. I think I'm the only lawyer in the room, if I'm correct. And I'm going to try to guide you through this particular area of the law. Is it or not allowed under trademark law to use sponsored advertising, to use sponsored keywords in systems like AdWords by Google? I've given a slide which you have in the booklet. I was a bit horrified when I read it just before taking it work to see how poor it is from. There is no image, no picture in it. It's probably, you will see it as very boring and dry. And truly, law is not the same as marketing. Every one of us has its own job, so his own job. So I'll try to make it less boring through the presentation, and I've put up a different set of slides at the end of. Okay, this is the one I'm going to use for the presentation today, with the objective to simplify a little bit and to let you better understand how we lawyers understand this problem and how we try to solve it. Being understood that the first problem for us is to know what we are talking about, because obviously lawyers do not use AdWords every day, as you can imagine. We have other things that keep us busy, and well, the first thing I need to clarify in this presentation is that at the beginning, when we lawyers try to show interest for this phenomenon of AdWords, everyone was very excited about the possibility of bringing Google in front of the court to have him convicted, to have Google convicted for use of trademarks or for some kind of liability, because it was making available a system and technology that would allow others, my competitors, to use my trademarks for their own profit. And many lawyers were asking themselves the question, is it or not allowed, and don't we have a very nice possibility to make a very big trial against Google and let's see what the court will think about this. I will not go into more details on that part of the subject, I mean the liability of Google, because it is in a large extent already settled. You may be aware that there was last year in March 2010 a judgment rendered by the European Court of Justice in a case involving Google France and Louis Vuitton and other opponents to Google who tried to challenge this position of Google and tried to have French court convicting Google for using trademarks or for allowing others to use trademarks in a way that would infringe on the rights of the trademark holders. But they failed, actually, because the French court referred the question to the European Court of Justice. It's a mechanism we have as lawyers. If we fear that the national judge will not apply European law in the proper way, we invite him to ask the question. It's called a preliminary ruling, to ask a question to the European Court of Justice with the view of giving a uniform interpretation of the law for the whole European area. And in that case, in the map reference here, the court in Luxembourg was of the opinion that Google itself is not making use of the trademark when it allows you as an advertiser to select a keyword and to display an ad on the basis of that keyword. And the court was also of the opinion that in doing so, Google is not liable for the data it is storing, for instance, the keyword itself. So, without going into more details on this topic, I'm available for the questions if you have. This is only to stress that now, you also, I'm sure you're aware that after this decision, Google modified its policy with respect to AdWords and decided to skip all the filters and to liberalize the use of AdWords and to stop filtering in a way that keywords that were restricted beforehand will no longer be restricted, and it is only on an ex post basis, if there is a complaint and if Google conducts an investigation that leads him to think that there is a problem, that they will remove the ad, they say we will remove the ad if there is a likelihood of confusion. I will now, in the following of the presentation, explain why this criterion of likelihood of confusion is important. But, I mean, the outcome of all this is, in my view, only that it has opened a battlefield for the advertisers, because we as lawyers don't have any possibility anymore of bringing Google before the Google trying to get Google liable for this, but of course Google has decided to liberalize the market and to let advertisers use trademarks of each other as keywords as in the widest extent possible. And we are left with very difficult questions to answer. Is it or not allowed to do things, for instance, I will show you some examples like that. Adidas is a keyword and an ad referring to Nike. Without any reference to the trademark, without any mention of the trademark in the ad itself, either in the link or in the text which is displayed. Movistar and two ads linking to Proximus on one hand and Place on the other hand. Groupon as a keyword and Coolbooks, which I guess is a competitor, and so on and so on. Very uneasy questions to answer from the lawyer's perspective. I will try now to explain briefly, if possible, what are the criteria that we use as lawyers. The starting point you have to keep in mind is that trademark law tries to find a balance between the rights of the trademark holder on one hand and on the other hand the general interest, the interest of the public, the interest of the competitors. And in the statutes on trademark law, for instance, the Benelux Convention on Intellectual Property, you will find that any trademark holder has at least 3 levels of protection. The first level is the so-called absolute protection. I can prohibit others from making use of an identical sign for an identical product. Second level is the protection against likelihood of confusion. If my competitor is trying to lead the consumers to believe that the products he is selling are coming from the same entity, from the same undertaking as mine, then there is a likelihood of confusion. It can be prohibited under trademark law. That's the core of the protection of trademarks, because the essential function of a trademark is to indicate the origin of the products. So we regard the creation of a likelihood of confusion as a, so to say, the essential form of harm, of infringement of a trademark. But there is a third level of protection which goes beyond the likelihood of confusion, provided that your trademark has what we call a reputation. A reputation means that your trademark is known by a substantial part of the market. Now, don't ask me to tell you what the substantial part of the market is, but it is obviously in function of the circumstances, in function of the investment that are made by the advertisers, by the trademark holder, that we can assess whether the trademark has a reputation or not. But if it's the case, then the trademark holder is protected beyond the scope of the products or the services for which the trademark is registered, which can be important in some AdWords situation, of course. These are the rights of the trademark holder, and the statute provides that there are limitations to these rights, and that competitors always have the right to use the sign for products which have been put on the market by the trademark holder or with his consent. It's the problem that we know as the exhaustion of the right, l'épuisement des droits, in French or in English. But it's not, this is not so much applicable for AdWords. The other exceptions or limitations are more relevant. Everyone has the right to use a sign as an indication of his or her name or address, even if the sign is identical to the trademark. Next limitation, you have the right to use indications that possibly could be a sign identical or similar to the trademark, indications relating to the kind, the quality, the quantity, the value, the intended purpose of a certain product or of a certain service. And the last one is that it is allowed to use a sign identical to the trademark if it is necessary to indicate the intended purpose of the product. For instance, if you are selling spare parts or if you are selling accessories that go with a certain device, and you need to inform the consumers, of course, that you are selling blades that go with that kind of shaver. I guess you see what I mean. This is the theory, and now I'm trying to explain you more in practice how this works with respect to AdWords. To do this, I'm going to base myself on this judgment regarding Google, which was rendered last year, but also on opinions more recently rendered by the Advocate General with the Court of Justice. The Advocate General is an advisor to the court. He does not deliver a binding opinion, but he recently delivered a very relevant, very important opinion in a case opposing Interflora on the one hand and Marks and Spencer on the other hand. It's a case originating from a dispute in the UK, with the UK court referring the matter to the European Court of Justice, just like the French court had done in the France litigation 2 years before. What we can say on the basis of this emerging case law is the following. Generally speaking, an advertiser will be entitled to oppose the use of a sign which is identical to the trademark for an identical product in two different situations. And this supposes that there is no mention or no display of the trademark in the ad itself. So only the selection of the keyword itself. To what extent is it possible or not? First situation, if the ad suggests the existence of an economic link between the advertiser and the trademark holder, that would be a problem. Or if the ad is so vague that the normally informed internet user cannot assess himself if products come from the same undertaking or from economically linked undertaking, then you are in the situation that I described as the likelihood of confusion, and it would have as a consequence that it would be prohibited to use the keyword, to use the trademark as a keyword. But there could be other more peculiar situation, and it is the one which has been referred to in this opinion in the Interflora case, because the reasoning is to say that Interflora, in that case, Marks and Spencer had used the keyword Interflora to display an ad which did not mention Interflora, but which mentioned Marks and Spencer. This is our website, and we also deliver flowers through the internet. But the reasoning of the Advocate General is to say Interflora is a famous trademark, it has a reputation, and it has also a first meaning, which is the identification of the company, but also it has acquired, through the use of it, a sort of secondary meaning, and it refers, generally speaking, to a certain way of selling flowers through the internet. Because if you, well, personally, I'm not a customer of Interflora, but apparently, if you see that mark, you know that it refers to a certain method of selling, of delivering the flowers, and you know that there is a network of vendors all over the world that use the same method. And the reasoning is to say that Marks and Spencer, by using the Interflora keyword, is trying to place himself like it was in the network of Interflora, while it is not the case. And it is a reason, according to the Advocate General, to say that there is also a likelihood of confusion. So you see two different types of situation where it would be prohibited to use a keyword which corresponds to the trademark of another. In the other category of situations where the ad displays the trademark, then it is a little bit different. If the trademark has a reputation, then there will be a harm to that reputation. There will be an infringement of the trademark in situations where the trademark is used as a generic term for referring to a certain category of goods rather than for identifying products that come from a given undertaking. This is a phenomenon we call the degeneration of the trademark. It's a threat to the distinctiveness of every trademark to have it, with the time, more and more used as a generic term, as referring to a certain type of product rather than to a product coming from a certain undertaking. There are plenty of examples of of names in French, like Hic is the famous one, which degenerated to a generic term, while in the origin it is actually a trademark. This is a situation you, as a trademark holder, are allowed to combat and to try to fight if it happens, and if you are at risk that the use of your trademark as keywords by a competitor would create this degeneration. The other situation where, according to the advocacy law, you would be allowed to oppose and to prohibit the use of the AdWord is when there is the so-called free riding. Free riding is a general theory in law when you actually exploit the efforts made by a third person without incurring yourself any expense and try to benefit from all the prestige and the fame and the investment made to create and to maintain and to enhance the value of the trademark. This is a general category, a little bit vague and to be assessed in function of the circumstances. Now, this all, I guess, still seems very theoretical to you, and we need to be aware also that AdWords are just a very small part of the trademark, of the general trademark, and we had in the past many other disputes regarding other situations where the trademark was used by the competitor for different purposes, in particular in comparative advertising. So it is important, I think, to have in mind, and I will not be too long with respect to comparative advertising, but it is important to have in mind that, generally speaking, if the legal conditions for doing some comparative advertising are complied with, then the trademark holder will not be allowed to prohibit the use of the trademark. But there are two important exceptions. The first one, again, is this likelihood of confusion. If the comparative advertising actually tends to create such a likelihood of confusion, such a risk of confusion in the mind of the consumers, then the comparative advertising will not be allowed. Second exception, if even in situations where the consumers could not in no event be misled as to the origin of the product, so in situations where there would not be a risk of confusion, there could still be a prohibition based on the trademark if there is a risk of infringement of the other functions of the trademark. It is important to have in mind that trademark law has as a general objective to protect the functions of the trademark. The first function is the identification of origin. Obviously, if everyone is allowed to use the word Rolls-Royce for cars, and for cars of a certain category, then the trademark will lose its distinctiveness. That's a protection of the indication of origin. But there are also the protection of the economic functions of the trademark, which are the investment, advertising, and communication functions of a trademark. The result of all these investments that are made by the trademark holder, and that result is not only in the distinctiveness of the trademark, in its capacity of indicating the origin of the products, but also in its capacity of creating publicity and advertising around a sign. Why am I pointing these rules on comparative advertising? Because they need to be reconciled with the case law we have on AdWords. And the question, now I'm going to summarize the situation. The question that remains, the question that remains is to see if the use of a keyword, and only of a keyword, where the trademark does not appear in the ad nor in the link, is it a form of comparative advertising or not? And is there a possibility for the trademark holder to invoke the risk of infringement to the other functions of the trademark, to the function of advertising, to the function of publicity, etc.? This is actually an unanswered question. I know it's formulated a bit in a theoretical way for you, but this is how we approached it as lawyers. And I will try to clarify with the examples. But to summarize what we can say now based on this emerging case law, I would suggest to distinguish two situations. The first situation is where there is no trademark mentioned in the ad, and in that case, the only situation where you can surely say that there is a risk if there is a risk of confusion. For instance, like it appears to be the case with Interflora, because of this reference to the commercial network of Interflora, which is created as an impression in the mind of consumers. But in other situations, and in many situations actually, the fact that you see a link to another vendor than the one you were looking for while typing in your keyword is not in itself an infringement of the trademark. So we seem to go ahead to a situation where it would be allowed to use keywords identical to a trademark of a competitor, and if we take the precaution of not displaying this trademark in the ad, then maybe it could work, unless creating likelihood of confusion, etc. And I'm not giving legal advice here. The situation is very different if the ad displays the trademark, because then the trademark holder will more easily be able to invoke the different levels of protection I have briefly touched upon in the beginning of the presentation. Conclusion: two decisions rendered in the beginning of this year by the president of the Commercial Court in Brussels, one in French, one in Dutch, two completely different conclusions drawn by the judge, not the same person, obviously. In the first case, a reseller of Belgium products is using the trademark VOE, and the trademark only very briefly appears in a part of the ad, and there is no other reference to VOE in the ad. The court says there is no infringement to the advertising function of the trademark, and there is no problem because also there is no likelihood of confusion, because in this particular market of telecom and tribal play, internet access and so on, the consumers are well aware of the battle ongoing between the cable companies and telecommunications companies like Belgium and Telenet. And there is no risk that the consumer would be misled and would believe that the ad by ADSL Telecom actually refers to products sold by someone who is part of the same undertaking as VOE. Okay, this is an opinion. It's also a decision because the judge wrote this opinion. The appeal is pending currently. I cannot tell you more until we have the decision by the Court of Appeal. But in the other case, which opposed two competitors selling do-it-yourself solutions, the trademark was Brainbox. It was used as a keyword by the competitor, Selfmatic, and it was a little bit the same. It was only the mention, a very brief mention of the trademark in the ad, Brainbox, Selfmatic, épargner, faites vous-même et épargner. And the court comes to the conclusion that there is an infringement to the advertising function of the trademark, and there is also a likelihood of confusion because the consumer doesn't know if the ad refers to the same undertaking as Brainbox itself, or from refer to another undertaking, and that's a risk of confusion, and it is not acceptable from the viewpoint of the trademark holder. So, but this is our day-to-day work. We have to face with different decisions in different situations, and it is true that before giving any legal advice, we take, of course, the time of carefully assessing all the situation, all the circumstances of the case. Is it a trademark with a reputation? Is it a Belgian trademark? Is it an international trademark? What market is concerned? Is it a market for new technology products or for grandfather products? And so on. Well, I have a number of examples. I don't know how many time I have left. Maybe feel free to come and talk to me after the break or after the study day to ask if you have more questions. Okay. Thank you for your attention.